Friends, hello and welcome to another episode of The Legal Breakdown. This is Jason Sansone, and I am happy to host another episode of The Legal Breakdown on KTLV 1220 AM radio here in Oklahoma City. As always, we want to remind our listeners that you can listen to the show every Wednesday from 5 to 5:30 during the drive home on KTLV 1220 AM. If you're outside of the range of KTLV 1220 AM's terrestrial radio reach, you can listen to it anywhere in the world on the TuneIn radio app, just so long as you have data connectivity. Or you can watch this feed live on Facebook through the Sansone Howell Facebook page on the Facebook live stream that we broadcast. Not able to watch live or listen live? Well, every episode is recorded and posted to youtube.com for the video, or you can listen to the audio as a podcast on Apple Podcast, Google Play Directory, and Spotify. Friends, today we're going to talk about something a little bit different, a little bit opposite of what we usually talk about. So far in this show, we've focused a lot, especially when we talk about bankruptcy, about the debtor, the individual who might need to file bankruptcy. We've talked about Chapter 11s, where the business, a corporation, might need to file bankruptcy, or even Chapter 7s, where a business may need to file bankruptcy. We've talked about predatory lending, consumer protection rights, all the ways that you as an individual can try to protect yourself from various lenders. But we're going to flip the script. We're going to turn things around today because it is important to touch on, and that is creditor rights. What if you're the person that is owed money? What are your rights, either as a business or individual? Because so far we've talked about the fact that, if you owe somebody money, all the things you can do to try to avoid, decrease, limit the possible pain that the creditor could bring on you. But we're going to do it the other way around now. We're going to explain what can you do to get paid in this episode of Creditor Rights. Broadly speaking, we're going to break this down and try to talk about two different areas, two different arenas. We're going to talk about outside of bankruptcy, pre-bankruptcy, and then we're going to talk about what would your rights be inside of a bankruptcy, all the things that a creditor can do to try to enforce their rights. So starting out, one of the first things that we can discuss is going to be, what is the type of debt? Okay, so your rights are going to be based on, do you have a security interest? Do you not? Does state law protect this? And we could spend a lot of time on this, so I don't want to go too far into too much depth other than, certain things fall into special categories. So obviously, if you're owed child support, if you're owed alimony from a divorce, there's opportunities available there either through enforcement agencies like DHS or legal ramifications. For example, most states, including Oklahoma, limit the amount that an individual creditor can garnish someone, but they're much higher and totally different when it comes to child support or child support arrearages. So if somebody owes you child support money, you may be able to get paid and have that enforced through DHS. But, going back, so somebody owes you money, okay? Just plain and simple, nothing else was done. You didn't sign any type of security interest. You don't have a perfected lien on anything. Then normally your opportunities are limited to pre-litigation collection or litigation. Pre-litigation is going to be similar to what we've talked about before when we talked about debt collectors and their strategies, how to settle debts. That's going to be calling, lettering, trying to negotiate, trying to basically bug the person into hopefully paying you or incentivizing the person into hopefully paying you. Litigation is just what it sounds. It's filing a lawsuit to begin to enforce your rights, to get a court order that says you're owed money and you have a judgment. Because once you have that judgment, now we can do all the other things that the law permits in the collection as a creditor. You could levy bank accounts. You could garnish recurring wages of an individual. You could seize property that if it's an individual is not exempt. If it's a business, hey, it's a free-for-all. There's no such thing as exemptions for a corporation. So you can start to take the assets necessary to pay for the bill, that judgment. So if somebody owes you money, You sue them, you win, they've got a boat, you can get the sheriff to take their boat and apply the value of that to the amount that you are owed. These are some of your creditors' rights. Other types of creditors fall into special categories where they may be able to get a lien before they even have to sue to enforce it. Most people have heard of these types of things. If you're a contractor, if you provide materials to somebody, if you're an auto shop, then usually you can get what's called a mechanic's lien. Those have the requirements, and you have to make sure you follow those appropriately, the time frame, itemized billing, and listing, but you just go down to the county clerk and you can record and file that, and now someone would have a lien against them. I caution creditors, be very careful in the way you use these, and also be sure you understand all the rules and requirements related to keeping your lien. A couple details there. You don't want to file a lien on somebody, obviously, whimsically, because if you do it wrong, you could be subject to money damages for your own recklessness. So just because I decide that I did work on a house and I'm upset and they didn't pay me, if there's a bona fide dispute or other issues at hand, be very trepidatious before you go record that mechanic's lien. In addition, where I see the biggest problems when it comes to these liens, where people typically don't realize it, especially the average contractor, is they're only good for a certain period of time. And if you don't do anything to foreclose that lien, in other words, file a lawsuit to make it a permanent judgment, it automatically extinguishes, it expires. So if you put a lien on a house because you provided roofing services and they never paid you for that roofing service, you put the lien on there. 2 years later, they go to sell the house. Are you going to get paid? Does that lien have to be satisfied? The answer is no. It's not good anymore if you didn't do anything to keep your lien. And so be aware of that as a creditor. You want to make sure you protect those rights. So we've touched on special categories of unsecured creditors, such as child support, such as mechanics, journeyman liens, materials liens. And we talked about then, if you're just an unsecured creditor, what some of your opportunities and rights might be. Obviously, that's limited to both pre-litigation and litigation collection. Once you've got that judgment, obviously, you're going to have to try to enforce that. Because frankly, a judgment's just a piece of paper. It's no more valuable the day after you get it than it was the day before you had it. You've got to find a way to get money. And so oftentimes creditors learn that you can't get blood out of a turnip. This is obviously, falls in line with what we've been talking about as far as filing bankruptcy. Just like people don't always have the ability or willingness to pay all of their bills. Well, if you're on the other hand of that and you're trying to collect, you learn that the hard way as well. So that leads to some of the things that lenders, creditors often seek to protect themselves, and that's a security interest. That's collateral. That's a lien up front on something. A house, a car, accounts receivables, business assets, inventory, plant property, and equipment. Depends on the type of loan, depends on the size of the loan. But those are all things that you look at before you do business or you lend. In addition, you might want to look at joint obligors, co-signers, for lack of better terms. That if someone lacks credit viability, if they're too high risk, you get somebody else then who you believe could be an option to enforce your rights if there's non-payment. So you're going to look at all those things to exercise. But going back to the idea of liens, once you have a lien, if someone doesn't pay you, you typically need to foreclose that lien. You need to take the steps to get your property back. So whether it's a house, if it's some other random assets, could be cattle, could be livestock, could be equipment. You're going to foreclose that. You're going to get a court order that now says, cool, you get the right to take it all back, so that you can sell that and apply that to the lien or the value of that contract, the debt, to find out how much is left owed. These are all things that you would want to do if somebody owed you money. But what happens now if that person files a bankruptcy? What if this individual seeks the power of a bankruptcy court either to liquidate or to reorganize? You've got different rights, things you got to consider. Well, the first thing you want to make sure if you are a creditor in any bankruptcy is, hey, make sure they're doing everything right. verify that they have dotted their I's, crossed their T's. You go over the case. Are there any grounds to object, period, to the filing? Are there any reasons you as a creditor need to appear and try to fight over this bankruptcy? Is it a serial filer? Have they filed in bad faith? Do they lack forms that should indicate that the case is ripe for dismissal if they didn't file all the requirements under 11 U.S.C. 521 timely, which is 14 days from the date of filing? If they ask for an extension, maybe they got that. But if they don't, they didn't file an extension, the court's probably going to give them flack anyways. You can look at everything and make sure the case is done right. You also want to make sure, if you're a creditor, that they do in fact have protections under the automatic stay. We've touched on, probably at length, that for debtors, when you file a bankruptcy, you get these protections. You get a laundry list of protections, but the biggest one is the automatic stay. It's going to make it so creditors aren't supposed to take any steps to collect or enforce their rights outside of bankruptcy proceedings. So if you're a creditor and you're in the middle of foreclosure, you're attempting to foreclose on your lien, they file bankruptcy, generally you would have to stop. If you're in the middle of a lawsuit just to try and get a judgment, you have to stop. If you have a judgment, you're trying to garnish somebody, you have to stop. All these things come to a screeching halt. You're not supposed to call them, you're not supposed to letter them, all that. And it applies to everybody. It's not some special thing of, oh, well, just some people do it and some people don't. The IRS is going to be stayed under the automatic stay. The student loans under the Department of Education are stayed under automatic stay. There are certain exceptions, like we've talked about, for example, child support, domestic support obligations. But otherwise, it's a big, broad tool. But the whole point of going in depth here is there's still limits, namely to repeat filing. The first time you file one bankruptcy, you don't have a prior bankruptcy, you're going to get the automatic stay. If you've had another bankruptcy proceeding in the prior calendar year, this is your second case within a year, and this typically happens in forms of reorganization like Chapter 13 or Chapter 11. It doesn't typically happen in a 7. But if you've had a prior bankruptcy within the 1 year, then the automatic stay is only good for 30 days, and after that, it lifts. Now, a smart debtor or debtor with smart debtors counsel would file a motion to extend, to continue the automatic stay onwards past the 30 days. But hey, you're a creditor. You see someone's filed a bankruptcy on their own. They're pro se. They don't have a lawyer. It's their second one within 1 year. Day 31, after that bankruptcy is filed, if they have not taken steps to continue the automatic stay, hey, it's game back on. You've got the right to continue to garnish them, to seize your property, to do whatever you need to do. Those protections went away. If it's the third bankruptcy within 1 year, there is no automatic stay at all when the case is filed. That if they file a bankruptcy, the typical stop the presses, hold up is not in effect. You have to file a motion to, in fact, to implement the automatic stay, and that's not going to be ordered on day one. So let's go with a scenario, okay? You've got a sheriff's sale pending on a house. You're the creditor. You're trying to foreclose on this as the mortgage lender. Sheriff's sale set. Now, typically, we file bankruptcy even the day before. Cool, the client is safe. They're going to be protected. That house cannot sell at sheriff's sale. If it's the first bankruptcy, that's true. If it's the second bankruptcy within 1 year, still true. Third bankruptcy within 1 year, house can still sell at sheriff's sale until that automatic stay is imposed. It does not have to be stayed because when you filed that case, you did not receive the automatic stay. So these are considerations for a creditor. If somebody owes you money, if you're a business or an individual, these are things you could look at, or of course, sophisticated counsel would know to look at. All right, so we've checked the stay, we checked all their documents. Now, so what else, Prairie Tail, can I do? Well, if it's a secured obligation, you could file a motion for relief from the automatic stay. In other words, even if the stay is in effect, you can ask the court to make it so it does not apply to you and your property. But what you're having to do is a couple things. First, you need to show that it's not necessary or relevant to the reorganization of the debtor. All right? Well, if it's Chapter 7, that's easy. There's no reorganization. If it's Chapter 11 or a Chapter 13, then you're going to look to see what their plan is providing. In that Chapter 13 plan, hey, are they asking to keep this house? Is it critical? Are they going to cure any defaults? Or have they said that they're going to surrender it anyways? So that's going to depend on your ability to get it. Are they providing adequate protection? In other words, can they make the normal monthly payment or the principal payment through the plan up front? If they're not providing any adequate protection, you have grounds typically for relief from the automatic stay. And is there any value, any collateral, any equity in the collateral that could be relevant to the bankruptcy estate? So if the property's underwater, if the house or the car is upside down, even in a Chapter 7, there's no reason to not have that abandoned back to the creditor. The creditor is going to have rights to go in to try and take that because it doesn't do any good. We can't show that there's value to the bankruptcy estate if there's no equity in it. So those are things you would look at when seeking a motion for relief from automatic stay. Maybe that doesn't apply to you. You're an unsecured creditor. You don't have grounds for a motion for relief, and the stay is still in effect. Well, in bankruptcy, we've got a special category of unsecured creditors known as priority claims. And just like I touched on, there's special classes and types of laws for creditors before you file bankruptcy. Same is true in bankruptcy. So tax debts, certain types of alimony, child support, domestic support, wage claims. So maybe an employer owed you money and they file bankruptcy. Well, will you get paid or not? Depends on, of course, if there's money in that bankruptcy to administer. But if there is, you're a higher order of creditor priority than everybody else. You're not just general unsecured. But all this leads to one of the most important things that you can do if you're a creditor, no matter what, and that is always try to timely file a proof of claim. Well, what is that? A proof of claim is showing what you believe you are owed as part of that bankruptcy case. You're laying out on paper, okay, they owe me $5,000. And you're also going to explain the categories. Is it secured? Is it unsecured? Does it have priority status? If it's priority, under what law are you claiming it's priority? If it's secured, how much of that amount is secured? Is it wholly secured? Is it partially unsecured? What's the interest rate? So you're laying out your claim and you're filing it with the court. Now, that could be argued over. You can object. The debtor can object to claims. There can be claims litigation. There can be disputes on that type of stuff. But assuming there is no claims litigation regarding your claim and that you don't have any disputes, that's what you're saying you are owed. And you want to make sure you do that. And you want to make sure you do it timely, because if you don't do it timely, the claim can be completely disallowed. And that time limit's going to depend on the case. Is it a 13? Is it a 7? Is it an 11? If it's an 11, the court's going to set special dates and deadlines and set those to everybody. But as a creditor, you want to be mindful of that. You want to stay on top of it. And frankly, if you are in the normal course, ordinary business of loaning money, these are things you should have policies and procedures for. I used to work for a company, and we had someone who specialized as the bankruptcy person. Every day we got notices of bankruptcy. They plugged them in. Their job is to calendar, look at dates. When are proof of claims due? Should we file one? Should we not? Is it an asset case? Is it not? So if this is something that doesn't happen to you normally, obviously you're not going to be an expert on it. But if you're a lender, this is going to happen all the time. You definitely either need an attorney that helps you with this regularly, or you need to know about this stuff, because you're going to be leaving a lot of money on the table if people file bankruptcy and you don't file proof of claims where you could be getting paid. You want to make sure you're getting paid as part of that case. So you're going to then file, ideally, and record this timely proof of claim. There's different dates for individuals versus governmental entities, so make sure you watch and you don't use the date that is applicable to governmental entities, because the tax commissions, the IRS, the state, they get a lot longer than everybody else. They don't always use it. They're actually pretty good about filing stuff on time because, hey, the tax man always wants his money and they're not about to mess around. But they could technically file much later than everyone else. What else could we do if we're in a bankruptcy? Well, you can appear at the 341 meeting of creditors. That's, heck, I mean, the creditors in the whole name. You've got the right to ask questions, to inquire of the debtor certain things. Did they fill out all the paperwork correctly? Have they made any fraudulent transfers, preferential transfers? Have they done anything? But what if your inquiry, the scope of what you want to do, is too big, it's too broad? You really need to drill down and ask a lot of questions beyond just the time available in a meeting of creditors. Well, you could ask for what's called a Rule 2004 examination. In the Federal Rules of Bankruptcy Procedure, Rule 2004 affords creditors certain rights to basically greater investigation. They could ask for depositions. They could ask for production of documents. They could ask for interrogatories, admissions, very similar to the discovery process in normal state or federal civil litigation. They're going to ask you to produce all this stuff up and tell you. It's also really important to remember, both as a creditor or a debtor, that while normal discovery is not a fishing expedition. What do I mean by that? I mean, you got to be on point. You got to be on topic. You got to know what you're asking for. You can object relevancy of things that don't have any bearing to the litigation. So time and time and again, courts have reined in the discovery of parties where they're going too broad, outside the scope of the case, not relevant, not appropriate. On the other hand, the United States Supreme Court has said a Rule 2004 examination is a fishing expedition. You have a very long leash as a creditor to inquire of the debtor about all sorts of conduct, about pre and current bankruptcy conduct. So, you may not know exactly what transpired. You may not know all of the things that you would normally need to know when you get into discovery in civil litigation. 2004 is an opportunity to learn that information, to have it beforehand, to use it to possibly do other things. What are those other things? Well, that is what then leading us to sort of a couple points. First, you could try to object to discharge or to confirmation. What are those things? We'll touch on confirmation first, even though I listed it second. In Chapter 7, there's no such thing as confirmation because we don't have a plan of reorganization. We file the case and then we just get a discharge. But in Chapters 11, 13, 12, the whole goal is to reorganize, so we have to have a plan. Eventually, it's got to be approved by the court. Well, as a creditor, you may have reason to stand in the way of confirmation. Your treatment under the plan may not be appropriate based on where you think you are. They're treating you as a unsecured creditor. You think your priority are secured. They may not be paying as much as you think they should be paying. It all depends, but you could file an objection to confirmation. You could set it for hearing. You could argue those points. In Chapter 11, you have the right to vote on the plan, depending on your category and treatment. You make sure you vote that if you have the right to vote, because if you don't like the plan, you want to vote against it. Otherwise, it could get confirmed. And we talked in Chapter 11 that it's possible to have a plan confirmed even over the objection of creditors. That's known as a cram down, but still, there's many, many things that a creditor can do to stand in the way of confirmation if they don't think they're getting a fair shake or everything that they're entitled to. Then, that leads back to adversary proceedings and discharge litigation. Well, what is that? Whether we're talking about a 13, whether we're talking about an 11, whether we're talking about a 7, you're not just guaranteed some entitled right to a bankruptcy discharge on one or all of your debts. The bankruptcy code, the courts have said time and time again, affords protections to the honest but unfortunate debtor. Meaning, you may have had bad circumstances and bad times. So long as you are honest before and during your bankruptcy proceedings, you should get a discharge. On the other hand, the dishonest debtor, someone who has committed frauds, is not entitled to a bankruptcy discharge. And so the area of law that you'd be looking at is typically, there's going to be a couple, but the biggest we're going to touch on for this, for Chapter 7 for individual debtors, is 11 U.S.C. 523. So if the creditor, or the debtor, if you're the creditor and you're looking at trying to keep someone from discharging an individual debt that's owed to you, if they obtained that money through false representations, through false financial documents, through, in essence, a fraud, they told you they make more money than they really do, they told you they own an asset that they actually don't, or they told you that they owe certain amounts of money, and in actuality they owe a whole lot more. They have a lot more debts than that. You might have grounds to try to keep them from discharging the monies that you lend them that they owe to you. Maybe they disposed of your collateral improperly. So you had a security interest against 50 head of cattle. they were supposed to give any proceeds from that back to you, or they're not supposed to sell it without your knowledge and consent, or you have to give the cows back to the bank. But they go out and they sell all that. And they take the money and they go to Vegas. Do you have grounds to keep them from discharging that debt? Absolutely. Disposition of collateral that is intended to injure the creditor, that is problematic. That's going to be grounds for discharge. So 523 actions are typically, or are, where a creditor is seeking to keep one debt from discharge, just that specific debt. On the other hand, it's possible to try to keep the debtor from receiving a debt across the board, from not receiving a debt in the whole bankruptcy. Well, why would that happen? That is much more related to usually the conduct either in the bankruptcy or very broad conduct before the bankruptcy. Bad faith as a whole. So you lied in the documents you filed with the bankruptcy court. You didn't follow bankruptcy court rules. You didn't follow orders of the court. You didn't follow orders or requirements of the trustee. You didn't turn over information or property that was required under the law. You might lose your whole bankruptcy discharge. Or as a creditor, you might keep the debtor from getting the whole bankruptcy discharge. Or if they're a serial filer, they have done certain things that would be improper. You borrowed money, you had no intention of repaying or knowledge that you'd have the ability to repay, that can keep you from getting a discharge altogether. Broadly, it was bad faith, your filing of the bankruptcy. And that'd be a 727 action in a Chapter 7. So 11 U.S.C. 727 could keep you from receiving a 727 discharge under that chapter, that section. So as a creditor, these are all things you want to be mindful of, you want to be aware of, you want to watch out of to some of your rights. Now, very briefly, I want to touch on some of the last but most complicated topics. We talked about some of this when we talked about Chapter 11s, that there's what's known as first-day motions because a flurry of activity happens in business cases at the beginning of the case. If you're a debtor, you're going to know this, you're going to have prepped for it. You're the one that's got the bombshell coming, and you may or may not have told your creditors that you plan to drop this bomb on them. Unfortunately, the creditor, on the other hand, may get blindsided with all of this work and activity that's going to happen and all of a sudden have to race into court. Well, if you're the one who's owed money, and especially if it's a Chapter 11 case, you have so many things you need to look at to determine what are your rights. If you are owed money for goods or materials that have been tendered to the debtor in a very short period of time before the filing of the case, you might have what's known as reclamation rights. You might be able to just have the right to get your stuff back, to take it back, because, hey, you just gave it to them. They filed bankruptcy. They haven't paid you. So the idea of the law is you might be able to get your things back. But if you didn't provide materials recently, maybe you provided materials, but it was a while outside the time period of the law, or maybe you provided services. Well, services, you can't recover the value or benefit of that. You may have other rights you need to be aware of. Are you what's known as a critical vendor? Hey, do they want to keep paying you for pre-petition claims because they want to do work with you post-petition? Are you going to provide any goods or services to the debtor after they file bankruptcy? These are some things to sort out. If you have a lien, then we've got to be careful what kind of lien. What's your treatment on that lien that they're proposing on day one? When we talked about Chapter 11, what's known as cash collateral. If you're a bank or a lender and you've got a lien as a creditor, any creditor, and you've got a lien against future accounts receivables, monies and cash, then the debtor isn't allowed to use any of that without court permission. So you need to make sure you're getting what's known as adequate protection. Are they going to treat you properly in this bankruptcy? So there's a ton of stuff to look at with businesses. That's why we didn't spend but the last 2 or 3 minutes of the show on that. Folks, it's time to start wrapping up. We've covered 30 minutes. We moved at a pretty brisk pace. We touched on a lot of stuff. You can look at this from two ways. If you're the debtor, hey, well, these are all the things creditors could do. But if you're the creditor, which was the goal of today's show, maybe somebody owes you money. These are some of the powers and protections you can take to protect yourself. Always remember, though, when in doubt, call experienced counsel. Friends, it's been a great episode. We appreciate everybody listening. Have a happy, safe week. It's a little cooler weather out there. We'll see you next week. This has been The Legal Breakdown with Jason Sansone.